Anybody? Hello. Anybody? Can anybody see me?
Not live. We're not live.
If anybody can hear me, in this very slow connection this morning. Is it, anybody there?
Yes, we're not live. We're not live, Norm.
I saw you for a moment, Mike. So you were there for a moment. Now I'm getting the buffer signal for you. Your name is there. There's a black screen. Luttrell says we're live. I don't know.
Yeah. Okay. I guess you must have hit the go live thing. So that's a little embarrassing.
Oh, well, I did. I was trying to figure out how to make this thing work.
Yeah, we left Norm at the controls here. So went with a cold open this morning. Good morning, everyone. I think Norm, maybe I'll have you just call me and I can have you talk via Bluetooth to the audience, and then I'm gonna basically mute you on your side, and we'll just keep you to be a grainy screen for now. Maybe your internet connection will improve. All right, 1 second. Let me get you situated here. Sorry, everybody. Good morning. Hump day. 1 second here, Norm. We're gonna get you. Don't say any curse words. I've got you on speaker, but I'm gonna feces. See if I can get you through the Bluetooth. All right, Norm, talk.
Hello.
I can hear you.
Hey, welcome everybody. Somehow the gods are not helping today. I'm up in Vermont on my normal hookup, but it ain't hooking up normally. So blame the deep state. And I've got a delay and an echo here. And now I realize how blessed I am to have any of you listen to me.
I'm gonna take you off of the Bluetooth. Can anyone hear Norm right now? He is talking. Say something, Norm.
Something. I'm still getting the echo.
Yeah, I'm getting the echo. Let's see.
Well, this is a little frustrating.
Yeah, no, we'll get it worked out. You just, All right. So Pat saying we got everybody both of us. We're just going to go with it. Okay. Norm, I don't know where the echo is coming though. Do you have maybe I'm trying to figure out where the hell that's coming from?
Should I get rid of my video image here?
Here, I'm just going to remove you there. Now what? No, that's not the
Still
issue.
there.
Maybe take me out. Get rid of your microphone. I think you're like too close to whatever microphone you're using. I love this.
Hello.
Still the same thing. All right. I'm going to take you off of this because that echo was not happening beforehand. Do your thing now. Is it still happening?
Hello.
All right.
No,
So
it's workable.
All right. So we're just going to do this sort of, however we have to. So Norm, you're going to be basically talking into my microphone through your phone.
Okay. So, we filed a petition in the U.S. Supreme Court yesterday. Those of you who are regular listeners know that Mike and I have a thing for the United States Constitution. We think it matters. We think it sets the metes and bounds of what's permissible in our society, guaranteeing to individuals certain rights and placing substantive limits on the conduct of government actors. Nowhere is this more obvious than in the context of the Fourth Amendment. The Fourth Amendment gives us each freedom from unreasonable searches and seizures. And Mike, I got to get rid of this screen here because I'm getting echo from my computer. Can you hear me still?
Excellent. That is perfect.
Okay, good. Now we're whatever it is, we've solved it. So nowhere is the limit on government more apparent than in the Fourth Amendment. The Fourth Amendment says that we shall be free from unreasonable searches and seizures, but then there's a warrants clause. And it says, and reasonableness is different than having a warrant because let's back up. Officers can arrest you either with a warrant or without a warrant. The difference in legal terms is the difference between an on-site arrest, that is an arrest that takes place in the officer's presence or based on speedy information, and an arrest pursuant to a warrant. And in the context, both arrests must be reasonable. In the warrant context, an affidavit needs to be filled out and sworn to before a neutral and detached magistrate. And that affidavit must lay out the reasons for there being probable cause for your arrest, a reasonable basis to believe that you've committed a crime. So the Fourth Amendment reads more or less in the warrants clause, but no warrant shall issue. But no warrant shall issue without without an affidavit signed in front of a neutral and detached magistrate. But I want you to focus, folks, on the words, but no warrant shall issue. In legal terms, shall is a huge word for lawyers. When you see the word may, you realize that the person charged with the responsibility to act or desist from acting has some discretion. They have the ability to act, usually according to a known
wiggle room. They can either act or not act. That's the whole point of a permissive word, may. You may get up from the table, but you may not. It's up to you depending on what the criteria are. But when the law says you shall do something or you shall not do something, that means there ain't no argument about it. Shall is an obligatory term. It orders it orders you to do or not do something. The Fourth Amendment says no warrant shall issue but for probable cause, and an affidavit signed by a person under oath or affirmation, meaning they have either sworn to tell the whole truth so help them God, or they have affirmed that they understood and understand that the obligation of an oath, and they are offering their statement truthfully, mindful of that. This is to place limits on government and to avoid the so-called general warrant problem. Under King George III in colonial practice, colonial authorities could get a general writ to search Mike's place for anything that might be a violation of the king's law. And that gave the magistrates the ability to rummage through anything, anywhere, depending on what Mike's place it meant. Did it mean, for example, Mike's place of employment, Mike's place of recreation, Mike's favorite restaurant, Mike's home? Well, in colonial times, it meant all of that. And so the crafters of the Fourth Amendment had a particularity requirement. That affidavit has to describe with particularity the place to be searched and the items searched for and the crime you are suspected of having committed. And there can be both search warrants and arrest warrants. Now, in life, in litigation, in the criminal practice, one of the things a criminal defense lawyer does is challenge the efficacy of a warrant, challenge whether it's accurate, challenge whether, in fact, there was some omission of material that is facts that matter that would tend to show that the warrant was not valid or not justified. This is what goes on in the criminal courts. So I say all of that because a warrant either describes probable cause or it doesn't. You either have probable cause for the state to seize your person or enter your property and search it, or you don't. You can't be half pregnant, and you can't have a half warrant, except you can in the courts of the United States. And so we filed a petition in the United States Supreme Court yesterday to challenge what's called arguable probable cause. And it's the half pregnant position of saying there may not be probable cause in this warrant, but it's close enough for government work. And the result is officers should be forgiven when they conduct what amounts to an unlawful search or what amounts to an illegal arrest. And it arises in the following factual circumstance. A man who is referred to in the pleadings named James Doe was at home with his wife and minor children one night when one of the minor children said something to his wife that led the wife to wonder whether the husband had been abusing the children, sexually abusing the children. She reported it to the Department of Children and Families the next day, and a full-scale forensic investigation was launched, meaning the children were taken to what's called a multidisciplinary team where a trained social worker interrogated the child, police officers observed, and based on the statements that the child reportedly made and what the officers observed, they got a series of 3 search warrants for James Doe's home and an arrest warrant for him. He was hauled into criminal court, accused of abusing his own children, thrown out of the home during the pendency of the criminal case, until the case was ultimately dismissed. Why was the case dismissed? Because the next morning, after the child had said something to the mother that got her all wound up, the child clarified what he said. Daddy hadn't touched his private part. He once spanked him. That spanking may or may not be a preferred practice in some households, but it's not child sexual abuse. The mom called the police and said, look, I want to clarify what I said yesterday. My child spoke to me and he made it clear. That information never found its way into the search interval. Similarly, the children later said that they felt intimidated, threatened, coerced by the interviewers into saying things about their father that just wasn't true. This information became part of the investigative file, but never found its way into the arrest or search warrants. When the dust had settled and the criminal case was resolved and it was dismissed, meaning, the guy could truthfully say in the fact that he'd never been arrested. That's one of the legal consequences of a dismissal of a criminal action in Connecticut court. He filed a lawsuit against the police, basically saying, you destroyed my professional life. You came close to destroying my family. You caused enormous harm to all of us by being reckless in how you handled the truth in this case. And you swore out warrants that left out information that was material, that was critical to the case, such that if a magistrate had seen this material, he would neither have authorized my arrest nor authorized the search of my home. Therefore, I'm going to sue you. And he brought that suit under a statute called 42 United States Code, Section 1983. It's part of the Ku Klux Klan Act of the 1870s. And basically it says that whenever a person's rights, federal constitutional rights, are violated by a state actor acting under color of law, that is, a person doing their job, this person can bring an action for money damages against the individual. It's an important statute for the following reason. Generally, the sovereign is immune from suit and his or her agents. Whether that should be the case or not is an open question. Erwin Chemerinsky, a constitutional scholar, basically says that he has said, he didn't basically say it, he has opined that sovereign immunity has no basis, no business in our federal constitution, and I think he's right. But the courts have read it in. And so for many years, the Ku Klux Klan Act in 42 United States Section 1983 remained a dead letter in American law. Then in the 1960s, enterprising plaintiffs began to use it against public officials who violated the rights of ordinary citizens. And a case made its way to the United States Supreme Court in 1961 called Monroe v. Pape. It was a Chicago case, and it was brought by a man and his family after police officers stormed into their home and held the family at gunpoint while they ransacked the home in search of evidence related to a murder.
Hey, Norm, do you know who the attorney was that brought that case?
I don't. I could look it up, but my computer's so funky right now. I can't. I don't trust it. I don't want to get triple echoes in here.
No sweat. We're clear as we're right now. So keep going. Sorry for the interruption.
Okay. So in any case, the case gets brought. The Supreme Court is left with a difficult decision to make, because if it, clearly Congress in the Ku Klux Klan Act had waived sovereign immunity against state officials, but yet this principle of sovereign, or it had waived. Well, Congress had tilted in the direction of waiving that immunity. It had basically said, we're going to permit money damages claims against the sovereign's agents. But no, there were lingering questions. Can a federal statute do that against state actors? And there's always this complex interplay between the rights that are assigned to individuals as a result of the federal constitution and how far they sweep into state court proceedings. The court in 1961 came up with an unworkable compromise in order to permit 1983 actions to advance. They retained the notion of sovereign immunity, saying, well, you're not really suing the sovereign when you sue his agent. You're suing these people in their individual capacities. And that's what Congress meant. And so we had the right to bring actions for money damages against the agents of the sovereign when acting in their individual capacity, they violated the law. And then the courts exploded with activity throughout the 60s and 70s and 80s while thousands of 1983 actions were brought against police departments and against state actors. The courts became overwhelmed with this work and began to think, maybe Monroe v. Tate was not such a good idea, because now we've got state actors who are spending a lot of time defending themselves against litigation from people seeking to hold them accountable, and they're not able to get the people's work done.
Well,
we need to find a way.
We have a fairly large contingent of our viewers who are active or former law enforcement. Historically, and I'm asking just because I don't know the answer to this question, when did police unions begin to emerge as sort of a, I guess, as a standard operating procedure for individual police officers, in recognition that there were necessarily adverse interests between it and the department? Individual officers in the department. Was it on the back of the proliferation of 1983?
That's a good question. I don't know the answer to that, and I will soon, because now that you've raised it, I've never thought about it. It's important to realize that at the time of the founding, we didn't have police departments. Police departments are a 19th century creation. And the large cities were the first to embrace them, typically in the early and mid 19th century. I believe police unions began to form shortly after labor unions in general began to form. That is in the late 19th century and early 20th century. But certainly individual capacity liability gave police officers an extraordinary incentive to band together to protect themselves, because these are guys that are going out, getting in a squad car or a horse and buggy, depending on the era, and they're going out to confront we the people at our worst. And let's be candid about what a police officer sees on the street. You and I, Mike, can talk until our gums bleed about reasonable people bargaining in the law's shadow, and how the government should stay off the people's back because the people have a natural right to liberty, this, that, and the other thing. And that's all fine as far as it goes. But it doesn't go far enough, because most often what police officers confront are people living at life's margins, who either through mental disease or defect have an inability to conform their conduct to the requirement of law, not in ways that make them incompetent or insane, but just make them a pain in the butt. Or individuals who are just really having a bad day and are temporarily not bargaining within the law's shadows, but rather are confined within shadows of their own making. And so, for example, two of the most dangerous calls a police officer can respond to are domestic calls and a motor vehicle call. Why? Because in both cases, the individual detained briefly or stopped or questioned is insulted. I was just driving my car. Leave me alone. Why are you doing this? I have a right. I have my rights. Or in the case of a domestic case, it may be that the husband and wife want to kill one another with steak knives and kitchen forks. And until the police officer arrives, and then the officer is invading their domestic tranquility, such as it is, and the officer becomes the enemy. So far more officer lives are lost in domestic calls and in motor vehicle calls than anywhere else. And the individuals who bring lawsuits often bring them as a result of a motor vehicle stop or what occurs in a domestic incident, because they're just so insulted by the presence of the state in their intimate lives. And so police unions, have an interest in making sure that the management of police departments don't throw individual officers under the bus. And police unions have an interest in making sure that officers are free to use their judgment in making these discretionary calls in tense, evolving circumstances that are potentially fatal to them. A cop approaching a person with on a motor vehicle stop has his hands near his weapon, not because he thinks you're a bad guy, but because he doesn't know if you're that 1 in 100 or 1 in 1,000 bad guys who's going to transform this into a potentially deadly confrontation.
Yeah, and the consequences of being wrong, right? Because most individuals say, you can't paint with such a broad brush, but when the consequences to the officer are literally life and death, right? You can't get that wrong.
No, and when you watch these videos online, of people who are mouthing off to cops at the get-go. I mean, there's one I just saw it. I wish I had the ability to get online right now. It was a woman, an older white woman. Had she been black, we'd be reading about it, everywhere. But she was probably in her 50s or 60s, Southern. The cop stops her, and she's immediately got an attitude. Why are you stopping? I'm just minding my own business. I need to see your license and registration. I'm not showing it to you, and I'm giving you the abbreviated version. I need to see your license and registration, ma'am. Well, you're not gonna. You had no right to stop me. I just want to get home. Ma'am, get out of the car. I'm not getting out of the car, And then the next thing, and she locks herself in. He's trying to get her out of the car. Next thing you know, she speeds off. He chases her, and it ends with her on the ground being tased, complaining about being tased. Ma'am, who do you think brought all this on? When he stopped you, ask him what happened. Why did you stop me? Give him your information. And if he was wrong, fight it out in the courtroom. Don't fight it out on the street. When I hear African-American people saying they give their children the talk, don't mouth off to police officers. Everybody should be giving their kids that talk. Officers on the street are tense. They don't know what they're confronting. If you've got a fight with the officer about his judgment and making a bad judgment call, take your fight to the courtroom. But if you fight it on the street, you're likely to lose, and you could lose your life. And that doesn't mean that there's systemic racism. It doesn't mean the cops are out to kill young black people. It doesn't mean the cops are out to kill anybody. They're out to enforce the law in a neutral and detached manner. And sure, they are informed by whatever biases they have as individuals. And sure, the nation has a long way to go to ensure that equal protection of the law lives in every interaction with the state and every state officer. But police stops are difficult. So let's get back to this business of arguable probable cause, which is where we started here some moments ago. So in the case of Mr. Doe, you'll recall, he's the guy who was torn from his home, accused of child sexual abuse, hailed into criminal court, fought his criminal court case, won it, got it dismissed because police had failed to let reviewing judges know that the children had recanted and that social workers had doubled down on the initial quote-unquote disclosure, because that's what social workers are trained to do, to believe the alleged victim and to regard every attempt to walk it back as an effort on the part of the alleged victim to bury an inconvenient fact. So Doe brought an action arising under the Fourth Amendment saying, wait a minute, these officers did not have probable cause. They didn't recite all the facts known to them in their warrant. I want to bring an action for unlawful arrest and for malicious prosecution.
Well, the difference and Norm, let's set the table a little bit for why the family would. Maybe it's obvious, but again, I think the facts here bear. Number one, he did fight it out through the court. So, like you said, he had the felony charges dismissed, but his family was torn apart. His reputation was absolutely ruined. Right, the mere leveling of these sorts of allegations of child sex abuse, etc. Are enormously serious, right? To the average, to anyone, but to the average family, we're talking about complete estrangement from family and other loved ones. Not to mention, right there at home, your family is being torn apart by those under the cloak and color of government authority via social workers, etc. In addition to the criminal court procedure. And everything else. So this is about a civil action that was launched as subsequent to the dismissal of those felony charges, because under those circumstances, the average reasonable person would say, yes, that family, that man deserves recompense for being put through that unnecessarily and erroneously.
And so he sought it. He sought it through a sometime guest of our show, John Williams, one of the deans of 1983 litigation. And he brought an action in the Connecticut District Court. The defendants, the discovery was engaged in complex discovery, depositions of the children, depositions of the officer, review of the documents, and the police officers then moved for summary judgment. Now, summary judgment, you lawyers know what it is, but you non-lawyers need a little bit of a quick orientation. A lawsuit involves application of law to disputes of fact. One party ran the red light. The other side may say, you ran the red light. The other side may say, no, I saw it was green. In that case, they have differing people there are differing versions of events. And if both parties are prepared to swear to it, somebody's going to have to decide which party is right. And if the issue that matters in that case is whether the light was red or green, and you've got two parties saying it was red on one side, it was green on the other, that's what's called a dispute of material fact, a dispute about a fact that matters. And that is the classic case of having a jury decide who to believe. And so when there are disputes about facts that matter, cases typically go to a jury. When there are when discovery has done and people have taken depositions of individuals, they've gotten statements under oath, they've gathered all the documents that are admissible and necessary to shedding light on what happened, and there's really no dispute about what happens. Everybody says the light was green. Then there's no need for a trial. A judge can make a judgment as a matter of law once there is no dispute about material fact. And so summary judgment is a pretrial device that permits judges to make decisions about cases that don't require the work of a jury to decide the facts. The parties have been given a full opportunity to discover the facts. Upon using that opportunity, they've discovered there's really no dispute about what happened. And because there's no dispute about what happened, the judge can accept factual representations as true and apply the law as to that dispute and decide what the outcome is. Now, parties can have disputes about what the law is, and what law is applicable in a given case, and that is usually what creates appellate issues. In the Doe case, the trial court, upon the defendant's police officer's application for summary judgment, concluded there was a dispute of fact about whether social workers had actually coerced the children and whether police officers knew it, and about whether the child had actually recanted, and if so, whether the social workers knew it. There were disputes.
In other words, the trial court allowed the civil suit to continue. The defendants attempted to end the litigation at a very early stage by asking the court to rule as a matter of law that there was no genuine issue as to material fact about the issue of probable cause. The court disagreed with the defendant's argument, right? An assertion. And it's not necessarily an argument because, again, Norm, you've recited the legal standard. A genuine issue of material fact is one for a jury. And as such, the legal standard is that given all of the facts as alleged in the light most favorable to the party not asking for that relief, right? Not asking for the summary judgment motion, is there an issue of material fact to be decided by the court? If not, as a matter of law, the defendant or the moving party, the one asking for summary judgment, will prevail. However, in the trial court's case, they said there was a genuine issue of material fact, and they denied the motion for summary judgment, which allowed the lawsuit to proceed forward.
And the defendants then took an appeal. And I don't want to get into the legal mechanics of why they were permitted to take an appeal, but they raised a defense of qualified immunity. And the rules as to appellate procedure as to qualified immunity are different from a normal case. But here's where the rubber meets the road on our case. When they got it to the appellate court concluded that even if there wasn't probable cause to proceed with the arrest and the searches, given the issues of material fact that were in dispute, there was arguable probable cause. And so our question is, what the hell is arguable probable cause? The warrant requirement says, but no warrant shall issue unless there is probable cause. It doesn't say anything about arguable probable cause any more than an obstetrics book will talk about a half pregnancy. So we've asked the Supreme Court, which has an interest in qualified immunity, because after all, this procedure is not defined by any statute. It's not defined by the Constitution itself. It's a judicial doctrine designed to help clear its docket. And if we're going to have qualified immunity, if we're going to give police officers state actors the benefit of the doubt in closed cases, that's one thing. But shouldn't we do so by known legal standards? And so our argument is that the notion of arguable probable cause, as applied to the warrant context, in the case of a qualified immunity evaluation, does violence to the federal Constitution, because it minimizes the probable cause requirement in a way that is constitutionally impermissible and permits officers to proceed to invade our homes and arrest us without probable cause, because an appellate court might say, well, it's good enough for government work. It's close enough for government work. When it comes to the Bill of Rights, it's either there or it's not. And we the people didn't agree to be governed by judicial discretion and fiat, and by people making up the law as they go along. We place substantive limits on the context of government, and the warrant requirement is about as ironclad as it gets. Now, as it turns out, every circuit court in the United States that has adopted the arguable probable cause argument, and the United States Supreme Court has never evaluated it. So we've taken a gamble in the James Doe case, and we filed a petition for certiorari. As I said earlier, it was filed yesterday morning. We've asked the Supreme Court to hear it, even though all the circuits use the doctrine. And we did it because qualified immunity has been much on the minds of justices lately. And they've shown some interest in it, and they've yet to grant the petition. A famous case, I can't recall where it arose, where that many people expected the court to grant certiorari and review probable causes as follows. Police get a call, disturbed man in a home. They arrive, a suicidal man is sitting in his basement or his garage, I don't recall which. He won't come out. He says, I'm going to kill myself. Police officers try to coax him. He pours a can of gas over his head. He says, I'm going to set myself on fire if you come one step closer. Officers say, well, we got to get this guy some help. One of them says, what should we do? The other one says, I don't know, I'll use my taser. The other officer says, but doesn't that make sparks fly? Won't that set him on fire? Yeah, maybe, but we got to do something. So they tase the guy and they toast him up. He burns to death. And so his family brings an action saying they knew there was a substantial risk of setting him on fire, and they acted anyhow. The trial court gave the men qualified immunity on the grounds that their actions were close enough to being justified to shield them from a lawsuit. The dead man's family, the decedent's family, took it to an appellate court, lost, and took it to the Supreme Court. The Supreme Court refused to hear it. So I'm fully well aware of the fact that this is a long shot petition. Petitions to the Supreme Court are always long shots, but there's just nothing ambiguous about the Fourth Amendment in the context of the warrant requirement. And, as I say, we filed the petition yesterday. We'll know within 60 days or so whether the case advances. And I hope it does. We did the deep dive.
Norm, one thing about this. There are standards of judicial review. And I know that we haven't really talked about that on this stream in particular, but we have in previous. But is that not sort of the narrow issue with respect to the Second Circuit Court of Appeals, I guess, setting this standard or applying this doctrine of arguable probable cause, because it reviews the facts that were before the lower court, the district court, in a de novo fashion? In other words, they set aside the district court's analysis of the facts as they were presented to the district court, and the Second Circuit Court of Appeals in this case, in applying the doctrine of arguable probable cause, it necessarily had to indulge a factual analysis all its own. Is that correct?
Yes, it is. And so the second issue we raised on appeal is whether the de novo standard of review is appropriate in this context at all, or whether it should be evaluated under a different standard of view called the abuse of discretion standard. And so here's what is a standard? A standard is a rule that a judge is supposed to use in deciding something. So when a factual issue comes before the court or before a trial court, and the rules of evidence and the judge is being asked to use the rules of evidence, the judge decides it's either admissible or not. And on appeal, when you want to evaluate whether the judge correctly applied the law, the standard of review is the abuse of discretion. With respect to factual findings, the judge has to be clearly erroneous in what he said. He had to look at the picture of the green light and conclude it was red. It has to be clear error. And that's a very difficult standard to make. The de novo standard says we're going to just forget about what the trial court did and why it did it, and we're going to let appellate court judges looking at the record make this decision on their own. And the result is that the result is what we got in the Second Circuit. The trial court was familiar with the file, evaluated the case, and concluded there was a dispute of fact. The court says, we looked at the same thing and you're just wrong. It's not clear to me that we should be permitting de novo review of trial court factual findings in the qualified immunity case, because we don't in other cases.
Well, and I mean, so especially
another way in which the deck gets stacked against plaintiffs in civil rights cases.
Well, it's absurd to me, because this is the Second Circuit reviewing the trial court or the district court's finding in a case where the actual warrant is not at issue. That was a separate criminal case where the felony charges were dismissed. No?
Yes.
And so in not that the outcome should determine, not that the outcome of that case should be determinative, at least conclusively, as to the liability under a 1983 action in this case. But it just seems even more absurd to me that the court essentially looks at the facts that were enough to merit the dismissal of the felony charges against the plaintiff in this case, and in a different case, and say, well, there was arguable probable cause in that case. I mean, and they're essentially saying that warrant should have been fine. And to me, that is tantamount to saying that he should have been convicted of those felony charges. And so doing,
maybe,
right?
I think what they're saying is it's just different standards, in the criminal, I think what they're saying is be happy you got the justice you got and leave everybody alone. The case was dismissed. There were defects potentially in the warrant. But they were, and so the criminal case rightly was dismissed. But what they're saying is, as to the officers, their conduct was close enough to the line that they should be given the benefit of the doubt. Now, to round out this discussion with your discussion about police officers and unions and, our former law enforcement listeners, they'll be saying, yeah, okay, often, we sometimes get it wrong, but we had a good faith basis for proceeding as we did. In the case of a child recanting, the experts told us that that's what children do because they feel guilty about outing daddy and they recant to try to get their beautiful lives back, their innocence back, but they can't get it back. And so we relied on the experts when we went ahead. And shouldn't we be permitted to do that? Are we required to satisfy the crystal ball test and get it absolutely right every time? And the courts are protecting officers who are making split-second judgment calls or judgment calls that are excruciatingly difficult over the long term. And let's not forget for a moment that while many police officers are well trained, many of them aren't. I mean, basically, it's a high school graduate who's doing job mostly for the right reasons most of the time. They're service oriented, but they're not people who've gone to law school, medical school, have necessarily gotten college degrees, although many of them have, or if they have, most of them don't have advanced degrees. And so let's not hold them to the rarefied standards of a courtroom. Let's hold them to the reality of the decisions they have to make on the ground, decisions we want them to make. And if we make it impossible for them to do their jobs without fear of civil liability, we'll all suffer. And Mike, that's largely been proven true with the defund phenomena. As police officers have become afraid to exercise their discretion in close cases, they're choosing not to act. I saw an interesting study that in some major cities, murder rates have as much as tripled in recent years because police officers just don't want to bear the risk of walking into a situation where they'll be blamed if they get a judgment call wrong. So, policing is excruciatingly difficult work, and I have enormous respect for cops. I've spent 30 years tangling with cops in courtrooms, and the first 10 years of my career, I was cocky, and I'm thinking, you idiot, anybody could have seen that it was different, And after, in the second 10 years, I realized I might be the idiot, that there was so much more to the case than I was prepared to assume. And as I began to understand what officers are up against, I began to have sympathy for them. I still believe, however, that there are bright line rules in the law, and the warrant requirement is one of them. And relaxing it with this notion of arguable probable cause tips the balance in favor of the state in ways that I don't think it ought to be tipped. And in an area that is our homes and our liberty, where our interests are fundamental and concrete, and we should have the tools to fight back in court if necessary. So again, we filed the writ. Our hope is the Supreme Court will hear it. I bring it to your attention, everyone, today. I realize this was a deep dive into legal nerddom, but I think it's important to understand the building blocks and the concepts of these cases to better understand the headlines you'll see around you. There's been a lot of discussion in the newspapers about qualified immunity incidents at the defund the police movement. Most of it's gibberish and doesn't mean anything. I'm hoping that after today's episode, you'll have a little bit better understanding of what lawyers are talking about when they talk about probable cause, and a deeper understanding of what's at stake for you and your family. As these doctrines get applied.
Well, and then, in terms of due process generally, I think that everything that you said regarding the difficulty of policing in the modern era strikes me as 100% accurate, a double bullseye, if you will. In my area of practice, I think that because, and you made an important distinction in terms of the, I guess the what we would call the credentialed class versus those who enter law enforcement with what we would objectively qualify as less education, right? Not less intelligence or anything like that, but just on paper, fewer credentials, fewer reasons for an office or a desk job with whatever. But where I am seeing the most pressure, and what I believe now, is that law enforcement is being used as a tool of that managerial class by and through the enforcement of state administrative agency regulations. And Norm, you and I, obviously, I've given you a small taste of that in the last couple of days with something I put in front of you. Yeah,
we're going to talk after. Sure, you gave me a ruling to read. I want to talk to you about it today at length.
And so that's where I think that perhaps the qualified immunity doctrine is best put on, is best scrutinized, is actually against those who are attorneys, against those who are a member of that managerial credentialed class, who sit in an office somewhere and wield the power to with the stroke of a pen or a phone call to deprive people of their privileges and their licenses and their due process. And so I think that
that's definitely within the context of the regulatory state. It's one thing to be an officer on the street responding to something happening before your very eyes. It's another thing to be trained, schooled, given time to make an application of what the law requires, and then to get it wrong. I'm far more forgiving of a person who fails a pop quiz, somebody who had the ability to cram and took the refresher course and then still got it wrong.
Yep.
There's a huge difference there.
Absolutely. And it's like, it's not even necessarily out of ignorance. And I'll stop short of saying anything that may make this may deteriorate any subsequent discussions. But suffice it to say that what Dawn is saying about accepting that people act in good faith, that's a very tough pill, especially in the context that I just brought up. Assessing that people are acting in good faith when they wield such authority and can distance themselves and isolate themselves from you as they wish after they have done something to harm you is quite difficult. But we'll more on that later. And I think that the discussion that we just started probably leads into the one that we're not going to get to today regarding the National Retail Security Survey for 2023, looking at organized retail, and especially at the statistics and figures based on the survey that show that the only real people in today's modern era that are allowed to use force in preventing anyone from stealing from a store are literal police officers, off-duty police officers, secondary employment, etc. And that's a lot to do with the fact that people feel as though they are going to be hammered for either by their own company or by the public at large for trying to defend the dignity of a store's ownership or a customer's ownership of certain items that they've purchased. So interesting stuff there. I think we also had another story about the climate court case over in Europe where some
we'll get to that tomorrow when we figure out these connection issues. I mean, next thing you know, Greta Thunberg is going to be running for UN president, and we're going to all decide to give it to her. And then what's going to happen?
Right.
Well, she'll say, "You will eat worms and you will like it."
Well, Norm, the phone in is a great alternative here. I think we've, trial by fire here today, but I think we've learned something really important about how we can get you on the phone when we have connectivity issues. So I'm glad that we at least did that. Want to just remind everybody that we are here every day, 8 a.m., Monday through Friday, on YouTube, on Rumble, and on X at LawPod Daily. You can also find each and every one of our podcasts after the stream is over on Apple Podcasts, Spotify, Google Play, Overcast, etc. Leave us 5 stars and a nice comment, or leave us alone. Norm, I'm not really sure how we're gonna. I'm not really sure how. I might just hang up on you here, okay? But I'll talk to you later. Bye, everyone.